So my presentation is going to touch upon the EU rules related to the enforcement of copyright, more notably the directive on the harmonization of certain aspects of copyright and related rights in the information society, the enforcement directive, and the latest directive, which is a directive on copyright in the digital single market. So lastly, I'm also going to make a reference to a non-legislative initiative put forward by the Commission recently, which is the recent recommendation on piracy for online events. First and foremost, it's important to note that in the EU, the rules on infringements of intellectual property rights included on copyright are set out in the Enforcement Directive, which is also known as IPRED. In addition, we have specific provisions in the InfoSoc Directive, which is the one I'm going to quickly explain you now. And this directive has rules for injunctions against intermediaries. Lastly, the rules on the copyright in the Digital Single Market Directive are relevant for uses that take place in the online environment, but they don't really affect the existing rules on sanctions and remedies. I'm going to explain this a bit more in depth moving forward. So, sorry, can you go to the previous slide? Thank you. So the InfoSoc Directive, just a very short background, this was adopted in 2001 following the need to adapt copyright to the new information society and the need to implement the obligations arising from the WIPO Internet Treaties, so the VCT and the VEPPT. The directive has a horizontal approach and it harmonizes rights and exceptions for both authors and holders of related rights, and we can consider this a bit like the constitution of EU copyright law. And in particular, with regards to enforcement, Article 8 of this directive states that member states shall provide sanctions and remedies in respect of infringements of the rights and obligations of right holders, and shall take all the measures necessary to ensure that those sanctions and remedies are applied. So the sanctions provided by the member states must be effective, proportionate, and dissuasive. And each member state shall take these measures necessary to ensure that the right holders whose interests are affected by an infringement activity can bring action for damages or apply for an injunction, and where appropriate, also apply for the seizure of infringement material. Lastly, this article also provides that member states shall ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe a copyright or a related right. And then just very quickly, this would be the enforcement directive. The full name of the directive is Directive on Enforcement of IP Rights, and it has two main articles that are applicable to copyright enforcement. The first one is Article 9, which provides for interlocutory injunctions. So these are provisional and precautionary measures. And they provide that they can prevent the infringement or prohibit the continuation of the infringement. And they are directed against the alleged infringer and also intermediaries. The second article is Article 11, which provides for injunctions. So this would be requested and granted within the procedure and on the merits of the case. And they aim at prohibiting the continuation of the infringement, and they are directed against the infringer and also intermediaries. And it is noteworthy that both of these articles are without prejudice to Article 8 of the InfoSoc Directive, so the one I just explained before. And just some information, but my colleague Veronique is going to discuss a bit more in depth later, just to let you know that some members are already applying these injunctions in a dynamic way. But more on this when we discuss the recommendation on piracy. And I would also like to explain a bit the new rules that we've adopted with regards to copyright in the digital single market. So the main goal of the directive here was to address the challenges faced by the creators and the creative industries in the online environment, because there was a need to establish new rules for a well-functioning copyright marketplace, and also a need to find regulatory solutions to address specific market challenges, in particular in light of the new ways of distributing and accessing content in the online environment. Now, the deadline for the transposition of this directive was the 7th of June 2021. And to this date, all member states have reported a transposition except for one. And it's important to note that this directive introduces a number of new provisions and new obligations. But in my presentation today, I'm just going to be focusing on Article 15 and 17, which introduced new rights and obligations for press publishers and platforms in the digital environment. So to begin with Article 15, this is not specifically a mechanism of copyright enforcement, but it's still relevant to take it into consideration, in particular with regards to the importance of this article in the online environment. So this article provides press publishers with a new right to authorize and prohibit the online uses, so reproduction and communication to the public, of their press publications by platforms. This means that the platforms can use the news publishers' content, but only if they have been authorized by the publishers to do so, and also if they remunerate them. So the objective with this article was to strengthen their bargaining position when they negotiated their use of the content by online platform. The right is only enforceable against information society providers for the online use of press publications. So it's some sort of enforcement mechanism, but it's very limited to a specific set of right holders and against a specific set of users. There is a carve out, very briefly to touch upon it. So it doesn't apply to private or non-commercial uses by individual users. It doesn't apply to acts of hyperlinking. And it doesn't apply to the use of individual words or very short extracts of the press publications. Then I'm going to discuss Article 17. So this article relates to the use of protected content by online content serving providers. The main objective of this article was to improve the right holders' bargaining position vis-a-vis these major market players and the remuneration for the use of their content on the platforms of these service providers, while also introducing a balanced framework that would consider the interest of the users. So this article aims at increasing the licensing between platforms and right holders, and it provides for the online content sharing service providers the need to obtain an authorization from right holders for the protected content uploaded by users on the platforms. If, however, platforms do not hold a license for the content that is uploaded by the users, they can be held liable for these uploads. However, there's of course mitigating mechanism for the liability of platforms under this directive. So this specific mechanism for mitigation the liability provides that whenever the content for which right holders have not granted an authorization, services can escape liability based on a multi-layer best efforts obligation. So this means that if licenses are not concluded, the platforms will have to make their best efforts to ensure that the content that has not been authorized by the right holders is not available on their platforms. They should make these best efforts on the basis of relevant and necessary information provided by the right holders. And however, failure to do this and to comply with this best effort obligation will make the platform liable for the presence of unauthorized content. Just a bit of a carve out, and also to explain a bit the interplay with the DSA here. In the case of illegal content that is used on other online services, so not necessarily online content sharing service providers, the rules of the DSA on the liability of hosting providers will apply, as well as general rules on notices. So again, this is very limited enforcement mechanism, more than limited, I would say it's maybe more nuanced and it's very targeted to a specific type, towards a specific type of hosting services. And then lastly, I'm gonna quickly touch upon the recommendation on combating online piracy of live events. Thank you. But just because my colleague Veronique is going to also speak about this very quickly, just the Commission adopted this recommendation, which is a non-legislative initiative. It's just a recommendation on online piracy of sports and other live events, and this was adopted in the 4th of May of 2023. And the recommendation aims to encourage member states, national authorities, right holders, and providers of intermediary services to increase efforts to combat unauthorized streaming of live events. This was recommended last year because piracy of live events have been proved to cause significant loss in revenue for live and sports event organizers and broadcasters, especially if action is not taken sufficiently quickly. So the recommendation aims to provide a holistic approach of the problems of piracy of live events for all players. There are several actions that the Commission aims to take. In particular, the recommendation provides indications on how the remedy is available in EU law. So the prompt treatment of notices and dynamic injunctions can be used in each specific case. But also, it also encourages close cooperation between the different market players, including right holders and online intermediaries, and also encourage national authorities to cooperate within a dedicated network, which is set by the EU IPO. So more on this, of course, later. Thank you very much for your attention, and I'm happy to take any questions.
So I will very shorten this presentation because we are already out of our time. But it's fine because this presentation, well, first of all, I'm very Delfosch as I was introduced. I work in the Observatory on infringement of intellectual property rights. So our aim objective is to enhance enforcement and to support the policy objective that were just explained. And what we are actually doing regarding copyright enforcement in the digital environment is really to try to reflect on one EU comprehensive approach that starts from the premises, and that where the DSA explanation and the copyright legal framework that was just explained by the colleagues. So we need first a robust legislation to be able to tackle efficiently piracy. Then it has to rely on a reliable, comparable data evidences. We also need to work on a stick. We need to have effective tools, remedies, procedure, and sanction to combat piracy. But if you do not have a carrot, if you do not have an available, rich legal offer for discouraging consumer to go through the pirate alternative, then it will not work. So we work a lot on this carrot, on this education, on awareness. And for us, what is being key is the cooperation with all the stakeholders, the right holders, the intermediaries online, the public and private sectors. So this is a little bit the structure of my presentation. Very quickly, what we are the EU IP Observatory. We have a quite clear mandate, which is to enhance enforcement of intellectual property rights, all intellectual property rights, including copyright. And our mandates revolve around these four calls of action: provide facts and evidence to support effective policy, create tools and resources to sharpen the fight against IP infringement, and raise awareness. But the observatory is more, and first and foremost, this is a network. We are a platform for a cooperation between the representative for national authorities, stakeholders, to exchange ideas and expertise on best practices. As I told you a minute ago, in this regard, our mandate is really reflecting on this broad EU policy strategy, stick, carrot, education and cooperation. And when it comes to the stick, we are trying to support Commission regarding any studies about the remedies, the measure, the sanction. And in particular, I mean, it was mentioned, we are trying to raise awareness and support public administrative authorities regarding the use of IPRED tools. Sorry, I went a little bit too fast. I'm on the slide before. Here, voilà, I told you we do studies regarding not only the value of IP, but also the impact of damages. And as I said, studies about IP right infringement, including a set of specific studies on copyright in order to give technical background, but also statistics. We have studies on public domain, we have studies on EU deposit system, and also, of course, on online copyright infringement. And then this is where I wanted to tell you. So about the stick, we try to inform and to give awareness about every measure and tools, not only with the public administrative enforcers, but also with the judge and also with a lawyer. So we try to work towards a better harmonization and understanding of this civil measure. So you have measure to preserve evidence, you have measure to facilitate the right of information, you have measure, precautionary measure or corrective measure, and you have also what we just mentioned, the so-called injunction, which is one of the most important tools in Europe to disrupt online piracy. We also have tried to have harmonized rules regarding damages and legal costs. So when it comes to stick, and when it comes to online piracy, there is this trilogy on liabilities. So first of all, and this was mentioned by Lucia about the Article 17, think about an online platform and think about a user uploading infringing pirate content on this platform. Who will be liable for it? So under Article 17, it might be possible that the platform engages direct liabilities according to certain rules. So this is the direct liabilities for making available to the public or communicating this infringing content to the public. But then there are also secondary liability rules, and this pops up to what Angelique said, meaning that we have DSA regulation that is not regulating secondary liability as such, but it is laying down the condition for exemption of liabilities, which is the basis for notification procedure. So based on the conduct of the online platform, was it a passive conduct, it will also be able then for this online platform to enjoy some liability of exception. And then we have this injunction, and it is important regarding liability because injunction apply irrespective of any direct liability or indirect liabilities of the intermediaries. It means that we call them injunction against innocent parties. You can have an order to an intermediary to block, delist or remove a content from online on the mere basis that this intermediary is giving access to content which is infringing. So we do not have to prove any liabilities of these intermediaries. The only fact that it is capable to put a hand or to prevent the infringement is enough. And then I will swiftly go about the injunction. We did a lot of studies to support, again, the policy discussion, starting from the premises that injunction in Europe are a key tool to tackle online piracy, but also to tackle new form of piracy, such as piracy of live events. And then we also are supporting this recommendation that was mentioned a few minutes ago by Lucia. We mentioned it, notably looking and trying to have an exchange of good practices between all the member states. And as you can see, in order to tackle live event piracy in Europe, many member states went away with their kind of own made solution, either through the case law. They have been adopting a live blocking injunction, meaning that this is an injunction that can repeat each time there is a live broadcast happening. And these case law exist in Ireland, Malta, Portugal, Netherlands. You also have very interesting trends which evolve with the setting up of administrative authorities that are really helping the judges. So on the basis of a blocking judicial order, an administrative independent body will support the effectiveness of the court order. For instance, the judge will say you need to block this list of services, and the administrative body will make sure that this list will also cover reappearing infringing websites This is the dynamic nature of a website. And then we have also many new initiatives based on purely voluntary agreements, where the right order representative are agreeing with internet service provider to block services on the basis of a substantiate request that an online service is proposing infringing content. Back to our holistic approach, we try to work a lot on the carrot. The carrot is aimed at raising awareness regarding the availability of legal offer in Europe. And for that, we have a specific pan-European platform, which is called Agorateka. You are European, you are also from, you can also use it. You go for Agorateka and you will be connected to every national-based offer of legal, cultural and creative content, music, sports, movies. So this is an aggregated platform, meaning that it is only giving access to national-based platform hosting this information. We have 24 countries participating, and we have a list of 4,029 legal offer sites listed. So this is a very wonderful tool also to have statistics and to have this overview of legal offer in Europe. We also work to facilitate digital copyright clearance with an offerwork database, and to support cultural heritage institutions similarly with an out-of-commerce work portal. Carrot education, we do a lot of things on IP in education. We really try to enhance creativity, innovation, entrepreneurship, responsible digital engagement among the young Europeans, which are a key subgroups. And then together with small and SMEs, these are the two subgroups, so youngsters and SMEs, two subgroups regarding which we try really to put a lot of attention, because they face many difficulties when it comes to assert their rights. We have a copyright MOOC. We also have online social media campaign, still targeting these subgroups. And we work with cities in Europe that we call authentic cities. We do a lot of counterfeiting program and awareness raising similarly than you. We have two FAQ, and I will almost finish with that. Two FAQ, the interest of this frequently asked question, well, you know all what is a frequently asked question. Interestingly here, what we did, because copyright is territorial and national based by nature, we try to give every European citizen the possibility to click on their country and to have access to answer to 15 questions that were asked to all the 27 member states. So this is a platform where you can find information on what you can do online on the basis of copyright. We did the same for teacher and students, so they also have their frequently asked questions, enabling them to find information depending on their countries. And then cooperation, there are three main streams of cooperation that I wanted to highlight regarding the fight against online piracy. The first one is this dedicated network of administrative authorities on live event piracy. This is a follow-up of the recommendation, the Commission recommendation on the combating online piracy of sport and other live event that was mentioned by Lucia. In order to following up on that, we created this very specific group of public sector experts on online piracy to share, to have a structured exchange of good practices, also to discuss the challenges. Some of them are implementing administrative pure process leading to IP blocking, which is which enable, for instance, to have a website, a service is blocked within a 13 seconds or sometimes minutes, a few minutes. So it's a process going very quickly. So we are really discussing all these new trends with those dedicated experts. And we are also trying to monitor the effect of the recommendation and to assess opportunities for further cross-border cooperation. And then we have an expert group cooperation with intermediaries. Interestingly, here we work with experts in their own name, independent capacity. They are not there to represent their company. So we work with experts from Google, Meta, from many online platforms, from right other sites, and they are all there to discuss specific topics which are leading to the setup of and the drafting of a discussion paper. We are specifically looking at the misuse of those online intermediary services for IP infringement purposes. So we have paper on domain name, we have paper on social media, we have paper on payment, the use of payment services to support but also to prevent infringement, on transport and logistics, and we had the last one on live event piracy. I will finish with the judge. We have a solid judge and prosecutor network, which is supported by case law monitoring that we are performing and a case law databases that we are also maintaining. This is a wonderful network with more or less 1,000 judges that have been participating to activities for the last 10 years. And they are discussing good practices, they are discussing their decision, and we are also trying to point to any divergent interpretation. For instance, in one country, you can have copyright protection for this bag, while in another country, the judge might decide no, there is no copyright protection at all because other requirements apply. So you see, we are really trying to harmonize the practices and understand the comparative law approach across the countries. And for instance, we are also discussing same case that are filed between some of the judge of the network, and so they can really cooperate between themselves. This case, for instance, was about the copyright protection of the Louboutin shoes with the red sole that you know well, and why in Belgium it was decided actually that those shoes were not copyright protected despite the obvious similarities with the other shoes. In other country, in Italy, it was decided that it was copyright protected. So you see, we have several challenges. We discussed a lot with this judge about those challenges that you can see here. So this is my concluding slide. Just to remind that the observatory is really helping the Commission and helping the stakeholder to close the circle from the registration to enforcement and raising awareness on the way. So we try to understand, we try to promote, to enforce, and to connect. And this is where I will finish. And I thank you very much for your attention.